Hi everyone, I hope you're enjoying the video so far. This is part 3 and we'll be discussing the second act in more detail. If you need help with understanding terminology or history, please watch video 1 which I've linked below. The second act is the Farmers' Empowerment and Protection Agreement on Price Assurance and Farm Services Act. This is a snippet of the act. If you'd like to read the full act, you'll find the link below. This act explains itself in the title. We will break this down. It is the farmer's agreement to provide the farmer empowerment and protection. It's a written legal agreement between the farmer and a business. It's done before the production of any produce. This is sometimes known as contract farming. Farming agreements may include trade and commerce agreements or production agreements, or a combination of the two. In a trade and commerce agreement, the ownership of the commodity remains with the farmer during production, and they get the price of the produce on its delivery as per their agreement with the company. In a production agreement, the company agrees to provide farm services fully or partially and make payments to the farmer for their service, regardless of the output. The minimum period of these agreements shall be one crop season, and the maximum period shall be 5 years. So we have discussed that there are two types of agreements. Now we will discuss what these agreements entail. Firstly, we will look at price assurance and what this means. It means the price of the produce is predetermined before production. However, the terms and conditions of the produce are also predetermined, such as the time of supply, quality of the produce, its grade and standard. We have already touched on farm services which are part of the production agreement. Farm services include the supply of seeds, feed, agrochemicals, machinery, technology and advice. If for some reason the farmer or company is unhappy, then there is a 3-level dispute settlement mechanism. Firstly, the matter goes to the conciliation board. If the matter isn't resolved, then the dispute is passed to the subdivisional magistrate, who will make the final decision. If the company or the farmer are not happy with this outcome, they can then appeal. So why are the farmers protesting? Once a farmer enters into a farming agreement with a company, he can no longer buy or sell this farm produce at the state-run mandi. Farmers are scared that companies might not pay them due to excuses like substandard produce. It has happened in the past in the case of sugarcane. Payments were withheld for years. Farmers were left in debt as they were unable to repay loans. Therefore, they had to sell or lose land. In some cases, farmers are committing suicide. Contract farming has destroyed farmers all over the world. The appellate authority is the highest level of appeal for the farmer against any private company. The farmer is unable to go to the Supreme Court or higher. Therefore, the Act is highly skewed in the favour of private companies. Here's a quick summary of the Farmers' Empowerment and Protection Agreement on Price Assurance and Farm Services Act. The new Act will allow farmers to pre-agree terms prior to production, price is assured before production, and farm services can be provided by the private companies. However, farmers lose out on state regulation and MSP. Once they have signed an agreement with a private firm, they can't approach the state. There's also a risk of non-payment if the terms of produce is not met, and farmers are unable to appeal to the Supreme Court. If you like this video, please like, comment and share, and make sure you subscribe because in the next video I'll be discussing Act 3.